Document in the appeal, Cameron Mathieson by his father Craig Mathieson and the Secretary of State for Work and Pension.
Lord Wilson will explain the decision of the court.
This appeal is about the rule in the Social Security Disability Living Allowance Regulations 1991 that a child under the age of 16 in receipt of Disability Living Allowance, which I will call DLA, is not entitled to continue to receive it while he remains an inpatient in an NHS hospital for longer than 12 weeks. Cameron Mathieson was born in 2007 and sadly died 5 years later. He suffered from cystic fibrosis and muscular dystrophy and confronted a number of other physical difficulties. He lived with his family in Warrington, and his parents, Mr. and Mrs. Mathieson, devoted themselves selflessly to meeting his complex needs. On 4 July 2010, Cameron was admitted as an inpatient to a specialist respiratory unit at Alderhay Hospital, Liverpool. He remained there until 4 August 2011. The Department for Work and Pensions had decided that Cameron was a severely disabled child who qualified for both the care and the mobility components of DLA. But on 3 November 2010, it decided to suspend payment of it with effect from 6 October 2010 in accordance with the rule. For by then, Cameron had been an inpatient at Alderhay for longer than 12 weeks. No further payment of DLA was made to Mr. Mathieson on Cameron's behalf until he returned home in August 2011. In these proceedings, Cameron has challenged the decision to suspend payment of his DLA for those 10 months. He has claimed that the decision was unlawful because it violated his human rights. When he died, Mr. Mathieson took over the claim on his behalf. The claim has failed before 2 tribunals and in the Court of Appeal. This court, however, unanimously concludes that the claim succeeds. Article 14 of the European Convention on Human Rights requires that rights falling within the scope of any other of its articles should be enjoyed without discrimination on ground of status. One of its other articles is Article 1 of Protocol 1, which provides a right to the peaceful enjoyment of possessions, which is taken to include state benefits. So the question is, did application of the rule to Cameron discriminate against him on ground of status? The court accepts that in October 2010, Cameron's status for the purposes of Article 14 was that of a severely disabled child in need of lengthy inpatient treatment. His DLA was suspended. He is to be compared with an equally disabled child not in need of lengthy inpatient treatment. That child's DLA would not have been suspended. The argument is that in that regard, the department discriminated against Cameron. A difference of treatment is discriminatory if it has no objective justification. It is for the department to show that the difference is justified, but in relation to social security provisions, the courts will afford particular respect to whatever arguments the department puts forward. The thinking behind the rule, similar to one which applies to those aged at least 16, but which kicks in when they remain in hospital for longer than 4 weeks, is obvious. It is that, irrespective of a disabled person's age, the expenditure relating to his disability is substantially less while he is an inpatient in an NHS hospital. We have had to look closely at whether, in the case of a severely disabled child, the evidence bears this out. The evidence of a nurse at Alderhay was that Cameron's care needs far exceeded those of any other child in the unit, that either Mr. or Mrs. Mathieson was resident with him in the hospital at all times, and that they remained his primary caregivers and administered a host of the necessary treatments to him. Mr. Mathieson's evidence was that, far from saving money as a result of Cameron's stay at Alderhay, it had cost him an extra £8,000 in petrol and numerous other respects. There is clear evidence that it is now normal for parents to face increased expenditure when their severely disabled child is in hospital. Gone are the days when parents were discouraged from staying with their child in hospital. On the contrary, they are now expected, even required, to stay with him and to help with all of the less specialized aspects of his care. 2 children's charities have conducted a survey which has found that 98% of carers provide at least as much care when their disabled child is in hospital as when he is at home, and that 93% of them suffer increased expenditure when he is in hospital. The department produces no evidence with which to challenge these findings. This court holds that the decision to suspend Cameron's DLA in accordance with the rule was unjustified, and that it therefore discriminated against him and violated his human rights. Our decision is that he was entitled to continued payment of it from October 2010 until the date when it was reinstated.